3, 2, 1, start. He argues that once the recruitment process is set into motion, the same is required to be brought to its logical conclusion in terms of the rules existing at the time of its initiation. Stop. In the instant case, without concluding the said recruitment process of 2009, the respondents have illegally replaced the same by a new recruitment process in terms of amended rules upon clubbing the vacancies. Stop. Such action is ex facie illegal and arbitrary, more so when the authorities have concluded the recruitment process of 2009 and have given appointment to similarly situated candidates in the district of Howrah. Stop para. According to him, the right of the petitioners to be considered for appointment is not solely based on empanelment. Stop. Having participated in the recruitment process of 2009 and having emerged to be successful in the de novo examination and the interview, the petitioners have earned a right to be considered for appointment. Stop. Such right, as crystallized in favor of the petitioners, cannot be defeated on a purported plea that the life of the panel had expired. Stop. Having taken a conscious decision to keep the recruitment process of 2009 alive, as would be explicit from the GO dated 12 June, 2012, the respondents could not have filled up the notified vacancies through the subsequent recruitment process conducted in terms of the amended rules. Stop. In support of such argument, reliance has been placed upon the judgments delivered in the cases of Richa Mishra versus State of Chhattisgarh and others, reported in 2016, 4 SCC 179, Purushottam versus Chairman MSEB and another, reported in 1996, 6 SCC 49, and State of UP versus Ram Swarup Saroj, reported in 2003, SCC 699. Stop para. He argues that even in case there is no provision towards publication of panel in the recruitment rules, it is imperative for the employer to publish the same and to bring it to the knowledge of the persons who participated in the recruitment process. Stop. The panels prepared and as submitted with a memoranda dated 11 June, 2015/17 June, 2015 do not disclose the names of the impaneled candidates. Stop. Such denial of publication of panel and non-disclosure of the names of the impaneled candidates have left the petitioners unaware about their position in the respective panels. Stop. Natural justice requires publication of the panels. Stop. Reliance has been placed upon the judgment delivered in the case of T. Narasimhulu and others versus State of Andhra Pradesh and others, reported in 2010, SCC 545. Stop para. Mr. Gupta submits that the final publication of the panel was withheld due to the interdict of the court. Stop. For such act of the court, the petitioners cannot suffer and their right cannot be defeated simply on a purported plea that the panel has lost its life. Stop. In support of such contention, reliance has been placed upon the principle of, within single court, actus curia neminem gravabit decode. Stop. There are existing vacancies and the petitioners who had been impaneled should be considered for appointment in the same. Stop para. Mr. Dhar, learned senior advocate appearing for the petitioners in WB4, adopts the submissions of Mr. Gupta and submits that the publication of the panels was interdicted by orders of this court, as would be explicit from the order of the appeal court dated 18th September, 2013. Stop. Upon empanelment, right stood vested upon the petitioners to be considered for appointment. Stop. Life was not infused in the panels so long the writ petitions referred to in the memoranda dated 11th June, 2015/17 June, 2015 were pending, and as such the employer cannot reject the petitioner's claim on a purported plea of expiry of the life of the panels. Stop. Having illegally clubbed the vacancies pertaining to the recruitment process of the year 2009 with the recruitment process initiated under the amended rules, the respondents cannot now deny the petitioner's claim on a purported plea of lack of vacancies. Stop. In support of such contention, reliance has been placed upon the judgments delivered in the cases of Dinesh Kumar Kashyap and others versus Southeast Central Railway and others, reported in 2019, 12 SCC 798, Satish Kumar Pal versus State of UP and others, reported in 2008, SCC online all 1459, Rajendra Bansal and others versus Buru, within bracket, dead through legal representatives and others reported in 2017 for SCC 202, East Coast Railway and another versus Mahadev Apparao and others, reported in 2010 SCC 678 and Prabir Kumar Sinha Roy and others versus the Honorable the Chief Justice High Court Calcutta and others, reported in 1996 to CHN 497. Stop.